One. Jamie, could we please take the roll?
Chairman DePalma.
Here.
Senator Seveny.
Here.
Senator Coleman.
Here.
Senator Acosta.
Present.
Senator Dela Cruz.
Here.
Senator Oyer.
Here.
Senator Lombardo.
Here.
7 members. There's a quorum.
Thank you, Jamie, and thank you, everyone, for being here tonight. In 2014, Prospect acquired Roger Williams Medical Center and Our Lady of Fatima Hospital in Rhode Island, converting them from nonprofit to for-profit hospitals, pursuant to the change in effective control, that being the CEC, and the Hospital Conversion Act, that being the HCA. The HCA approval included several conditions which needed to be satisfied. And currently, Prospect/CharterCARE is now going through yet another CEC and HCA. Tonight, we have before us on the agenda 3 folks who were invited to provide us an update. The first, I'm going to address all 3 of these, and then we'll go through each one of these individually. We've invited the Rhode Island Attorney General's office, and we're fortunate to have Miriam Weizenbaum with us, who's the Chief of the Civil Division for the Rhode Island Office of Attorney General. Following Miriam will be Christopher Kalachi, Esquire, General Counsel for United Nurses and Allied Professionals. And following Chris, and certainly not last but not least, we have Jeffrey Liebman, who's the Chief Executive Officer for CharterCARE Health Partners. Subsequent to that, we will have public comment, and then we'll have closing remarks. So members of the committee, the way we'll execute tonight's hearing, we will have each of the presenters provide their presentation or their talk. I think we only have one presentation for the night. The rest will be conversation about what we've asked them to address. And prior to them addressing their conversation, I will articulate what we've asked them to address. So first up, we have Miriam Weizenbaum from the Office of the Attorney General. And we've asked Miriam to provide us an update on the conditions associated with the 2014 HCA, the Hospital Conversion Act, addressing the topic we mentioned earlier, the resultant commitments associated with the 2014 HCA, and other pertinent topics associated with the 2014 acquisition. We also asked for her to request she provide her insight and concerns on the pending HCA application addressing to effect a buyout of the private equity investors associated with Prospect/CharterCARE. And some of the words I use there come directly out of that which has been filed. So without further ado, I'd like to turn it over to Miriam. So members of the committee, you should have received all of the information from each of the presenters, from Miriam Weizenbaum from the Attorney General's office, from Chris Kalachi, so representing General Counsel from UNAP, and from Jeff Liebman from CharterCARE, and the information they provided as well via Chris Vitale. And Chris, thank you for helping us here tonight. So Miriam, over to you.
Great, thank you very much. So thank you, Chairman DePalma and members of the committee. I appreciate the opportunity to talk to you about the work that the Office of Attorney General is doing with respect to the transaction that we're facing right now concerning Prospect Medical Holdings and Prospect CharterCARE. The chair, as he indicated, asked us to address, first of all, the 2014 transaction, which was reviewed by this office. In order to discuss that transaction and just to understand the context in which both that transaction and the current one are being reviewed, I wanted to invite our healthcare advocate, Jessica Ryder, a Special Assistant Attorney General in the office, to quickly go through the Hospital Conversion Act, and so that members of the committee can understand what what is the context in which our review is taking place. So I'm going to turn it over to her, and our workaround with the technical difficulties is that she'll let me know when to advance the slides, and we'll just go through this quickly and then address the 2014 conversion and the current conversion. So let me turn it over to Attorney Ryder.
Hi, good evening, everyone, and thanks again for having us. As Miriam said, I'm going to briefly talk about the hospital conversion process that this is the process we would have taken in 2014 and something similar here to what we're doing today. So next slide, Miriam, please. So just briefly, there are 5 key purposes of the Hospital Conversion Act that we are always considering with all of these transactions. The viability of a safe, accessible, and affordable healthcare system, probably, front and foremost of that. I won't read through the rest. They're come directly from the statute. Next slide. So conversion means any transfer of 20% or greater of any of the following in a hospital. So ownership, control, membership interest, authority, or voting rights. So that was, clearly triggered back in 2014 with the sale, and also triggered today with the buyout that's happening. Next slide. Oh, great. So under the Hospital Conversion Act, all conversions require review and approval from the Attorney General and Department of Health. We do work together to review those conversions concurrently, although we each have our own statutory framework that we're working off of, and I'll go into a little bit more of that later on. So the change in effective control process, also called the CEC, that's a parallel process that's conducted solely by the Department of Health. So HCA is a process that both the AG and Department of Health are involved in. CEC is a different process that is before the Health Services Council, a public body. They review the application and recommend decisions to the director. The director is the ultimate decision maker. There are 4 criteria under all CECs. So just to be clear, I think that can be confusing, but there is a separate process that's going on. It's run parallel, that is, run solely by Department of Health and goes before that public body for review. So briefly, the HCA process, we have preliminary discussions, the initial application getting to completeness, a review period of 120 or 90 days, decision, and then monitoring. The 2014 transaction was under 120 days, and this one was initially and has been extended. So during that review process, we're doing lots of written questions and document requests, holding public meetings, conducting statements under oath, hospital tours, and other investigations. Just to clarify, back in 2014, the interviews were done, they were not done under oath. There was, the statute had been changed since 2014, so that is something we are doing moving forward. And as a caveat, during this current pending transaction, hospital tours are just kind of off the table given that we are in a global pandemic. So briefly, what's in the initial application? And, oh, yeah, Miriam, I think you can go to the next slide. So the criteria that we're looking at through the review here, there is, 31 now, 31 or 34, but I kind of broke them down into 6 different buckets. It's governance, conflicts of interest, charitable assets, antitrust, valuation of the transaction, and the transacting parties, as far as their standing in the community, their competence, their ability to operate hospitals. A caveat to this, that antitrust was just recently added, so that wasn't something that fell under the HCA authority in 2014. And charitable assets were in play in 2014 as the CharterCARE was a nonprofit moving to a for-profit. Won't be at issue in a for-profit to for-profit transaction, what we're dealing with the current proposed transaction in front of us regarding Prospect. And then we get to decision. And that decision is going to be approving with conditions, or denying with conditions related to the proposed conversion, our review criteria, and the purpose of the HCA. So back in 2014, the Attorney General's Office approved the Prospect CharterCARE transaction with conditions. So a brief review of that 2014 Prospect CharterCARE transaction. CCHP entered into a joint venture with Prospect Medical Holdings called Prospect CharterCARE, and CCHP is CharterCARE Health Partners. That was the entity that held Roger Williams and Our Lady of Fatima, at the time St. Joe's. They had affiliated in 2009, also a conversion that was reviewed and approved by our office with the intention to achieve efficiencies. They both were struggling financially at the time, and the hope was to joining together would achieve efficiencies. Yet a couple of years later, they were still struggling to remain viable. Pension losses were unsustainable, and the physical plants needed updates that the entity just couldn't afford to give them. This joint venture of Prospect CharterCARE was an ownership of 85% Prospect and 15% CCHP. So the old co-entities, as they're called, were going to remain in as partial owner under this joint venture with a 50-50 board. What that means is that 50% of the Prospect CharterCARE board was appointed by Prospect, 50% was appointed by CCHP for a 50-50 board. The purchase price of that 2014 transaction was a total of $95 million. $45 million was paid at closing, $14 million of which was allocated to the St. Joe's pension, and $50 million in long-term capital commitment to be paid by Prospect over the 4 years post-closing. That amount was later increased to $62 million over 6 years. Prospect CharterCARE sold Elmhurst Extended Care Facility and asked that the proceeds of that sale be included in the long-term capital commitment and that they get an additional 2 years to spend that money. So that transaction was approved by the Attorney General with 30 conditions on May 16th, 2014. 30 conditions, I've kind of grouped them here. One of the big ones was the transaction must be implemented as proposed, including spending that $50 million long-term capital commitment over 4 years, as I said, later increased, and $10 million routine spend per year. There was limited overlap between local boards and other provisions regarding board oversight, and there was notification of amendment to agreements, corporate documents, regulatory notices out of the ordinary course, and post-closing contracts. Monitoring. So after this transaction closed, the Attorney General retained an independent monitor to report on compliance of most of those conditions, about 23 of the 30. And those were conditions that were ongoing. Many of the conditions were either, met right immediately after closing or as a result of the closing. That independent monitor provided 3 reports throughout the course of the monitorship and found substantial compliance with the conditions. So here specifically the financial commitments, that would be that $50 million that later became $62 million and that $10 million per year. Here is the big picture snapshot of what was submitted. Submitted figures meaning there was documentation submitted to our independent monitor of 66, almost 67 million in long-term capital expenditures. They were able to confirm about 64 million of long-term capital expenditures. The routine expenditures documentation was submitted for about almost 52 million. They were able to confirm, a little under 51.5. That routine expenditure was 2014 through 2018. The long-term capital commitment was completed in 2019. Just to highlight some of the big projects that the monitor looked at through documentation was the Roger Williams Medical Center Emergency Department, their HVAC update, and pharmacy expansion, and also for Our Lady of Fatima, they had an emergency department renovation and overhaul, HVAC update, and Roger Williams also had a renovation to their main entrance, and practice acquisitions were also included in that long-term capital expenditure. And that's the end of my slides. Miriam, I'll turn it over to you.
Thank you. That brings us up to the current transaction. But before I address the current transaction that's under review under the HCA, I'd like to speak to one of the most significant issues that arose in connection with the 2014 transaction, and that is the St. Joe's pension. As members of this committee know, this was the pension on which long-term workers devoted to the mission of care for the sick, relied. At the tail end of the 3-year monitoring period, or the 3-year period over which the statute gives the Office of Attorney General authority, at the end of that period, the St. Joe's pension went into receivership. And then the pension ended up being battled out in litigation. The pensioners deserved and received aggressive advocates on their behalf, and those were advocates who fought until the pension paid was far closer to the pension that was due. The members of the Office of Attorney General's healthcare team, current healthcare team, and I were not part of the 2014 conversion, but to the extent members of this committee have questions about the St. Joe's pension and that process, we'll do our best to either answer them tonight or provide answers to you. I wanted to put that out there because I think that was one of the most significant issues arising out of the 2014 transaction. I will say that our office sees the experience with the pension as highly relevant to the transaction we're currently reviewing, because in every transaction subject to the HCA, and in fact, in every matter under our healthcare authority, it's really our job to recognize what may be in conflict with the healthcare of Rhode Islanders. The conflict inherent in for-profit healthcare is, on one hand, the goal of profit, and on the other hand, the obligation of care. And so it's a recognition of that conflict that is part of the review we conduct. So because the question posed by the chair was, and by the committee, was extended also to the current transaction, I'd like to, here's what I can talk about concerning the current transaction. First of all, so the committee understands, the Rhode Island hospitals are held within Prospect CharterCARE. And there are a number of companies in between Prospect CharterCARE and the top of that ownership chain. At the very top of the ownership chain is a parent company called Ivy, and Ivy owns Prospect Medical Holdings. Prospect Medical Holdings owns a bunch of different hospitals and hospital/healthcare systems. And again, down that chain, it owns Prospect CharterCARE, which owns our hospitals. Leonard Green is a private equity company. They own about 60% of that very top company, Ivy, the parent to Prospect Medical Holding. Leonard Green owns about 60% of that. The two current minority stockholders are Sam Lee and David Topper. And together they own essentially the rest of Prospect Medical Holdings. So what's the current transaction? The current proposed transaction that's undergoing our review is a buyout of Leonard Green. So Lee and Topper want to buy out that 60% owner, which is that private equity company, Leonard Green. If that transaction is approved, then Lee and Topper would be the new owners and sole shareholders. And the parent, instead of be called Ivy, would be called Chamber. So that's the transaction that is currently under review. And because it involves more than a 20% transfer, remember it's 60% owner, so it's more than 20%, it triggers the Hospital Conversion Act and therefore our review. So even though this transaction will affect all these other hospitals that Prospect Medical Holdings owns, it will also affect who owns our hospitals, so it's undergoing the review. So where are we in the process? The application was, quote, deemed complete. Attorney Ryder described that in her presentation, that certain materials are submitted. When the questions in the application are deemed complete, then we accept the application. But following that, we ask many, many questions. And in this case, we sent to the parties 276 separate requests over the months since the application was finished. We've sent 276 requests and taken testimony under oath of 15 witnesses. So that's where we are in the process. I think another key feature of this transaction really emanates from a policy and commitment on the part of Attorney General Morona to transparency. So what is particular about this is a great deal of really all the information we can has been posted to the website. And we provided members of the committee with a link to that location where those documents are posted. And you can see the kinds of questions that were, the application, the kinds of questions that were posed, et cetera. So I can't talk a lot more about the current transaction because as a regulator, we have a legal obligation to express findings and conclusions in a final decision and only in a final decision. And that limits what we are and what I'm able to talk about with respect to the current transaction. What I can say is where we see the locus of our obligation, which frankly is quite succinctly laid out in Section 28 of the Hospital Conversion Act. That's the section there, as Attorney Ryder described for you, there are all the criteria that we can consider. Not all of them apply in every case. For example, in this, there are no charitable assets, for example. But those are all the criteria that you as legislatures have given to our office to consider when we're reviewing a transaction. At the end of that, we need to make a decision whether to approve a transaction, to not approve it, or to approve it with conditions. In the conditions section of the Hospital Conversion Act, the statute states that the Office of Attorney General will look at, and we feel it's our obligation to ensure that, and I quote, the acquirer's adherence to a minimum investment to protect the assets, financial health, and well-being of the new hospital and for community benefit. So again, while I can't describe the particulars of the investigation and the review, we're only allowed to do that in a final decision, I can tell you that it's that consideration that really drives what we're doing, as well as the other elements that you've seen discussed in the previous decision, like governance, like tax implications, those kinds of things. But it's really the adherence to a minimum investment to protect the assets, financial health, and well-being of the new hospital and for community benefit that that really shapes our review. I want to thank members of the committee, and we're happy to take and look forward to taking any questions, which I understand are going to be at the end after everyone speaks.
Miriam, I think we're going to do questions with each segment as we go along, so because there might be some as we go there. So we'll do this round robin, but the first question I have, you don't have to go back to the charts, but and there are several from reading the voluminous amounts of information, but the first specific question, you mentioned 266 questions/requests and 15 witnesses testifying under oath. All of that information is all made available, correct?
Good question. Actually, not all of it. So when
Any reason why it's not?
yeah. So when an entity, in this case, any entity that's involved in a transaction submits information, some of that information is going to be deemed confidential. And I can just briefly describe that process. The way that works is that the party will identify, this is like confidential, in the realm of sort of business information. And then we review it to determine whether it fits within the legal definition of confidential information. And if it does, then we agree to the redaction.
So Miriam,
Other than that,
just to follow up to that, is there a listing somewhere of the 266 questions/requests and the 15 witnesses, so that if somebody wanted to go find out more what's not there as opposed to what's there, does that exist on the website?
yes, it does. All of the questions are on the website. I'm just looking at the list now. And you can see where there have been redactions.
Okay. The next question then becomes, you had the Attorney General criteria, and this really aligns itself with not-for-profit to profit, I believe, right? You said that charitable assets, most places may not have a charitable asset if you're a for-profit, I guess. Should there be different criteria or additional criteria you use? Because I'm not certain we've had this have we had a situation like this? And I know you weren't part of the prior 2014 review, correct? Just wanted to make certain for the record there. So given that, shouldn't there be other criteria that we use from a state perspective when we look at for-profit to for-profit?
Yeah, there are different criteria in the HCA for reviews that do not involve for-profit. So the criteria that we're using involves that for-profit element. So there are different criteria.
Okay, one last time, I'm going to go to Senator Coleman next. I'm going to go around the screen here. So, in looking at this, and you explicitly called out, and we're not going to fixate on it, but it was an issue here with regards to while 2009 CCHP affiliation, et cetera, struggling to remain viable, the pension losses were unsustainable. Well, we converted this not-for-profit to profit hospital, and the pension became even worse, from what I understand and what I've been able to see, from what was potentially looked at in 2014 to what happened after. I know I'm asking you to comment on something for which you were not a part of, but it's yours now, right? It's you're there now. It's yours. Whether you choose to want it or not, it's yours. Does that say something about the process?
I think it does, to the extent that that pensions were not a criteria for review in the HCA as it existed in 2014. However, having said that, there was I can tell from looking back at the documents that there was a consideration of the pension because 14 million was put towards the St. Joe's pension. So there are, there was an opportunity to look at that. It appears that it was looked at and that an amount was put towards it. And, I think we can tell that the amount was not adequate.
Okay, so just a comment, you don't have to make a statement about it, but clearly that part of the review was lacking. If what was identified in the review and analysis then compared to what we've seen transpire over the last N number of years, we missed something somewhere as a state.
I think clearly more was needed. Personally, I have not gone back and reconstructed how that number was arrived at, what was relied upon.
Okay.
I know that was very closely investigated in the pension case. That's my impression. So there was a miss somewhere. Where it was is not a review that I've done.
Okay.
But I agree there was more needed, and the route through which it was obtained is not the route that we should be relying on. That is litigation.
Thank you. Senator Coleman.
Mr. Chairman, I'm sorry to ask you all to go back to the slides, but could we
Okay.
bring up slide 16 again, please?
I'm sorry, which number?
16.
Senator, what does slide 16 have on it? I don't think I have page numbers on it.
These were the difference in projected
page?
spending and actual spending. Basically, I noted a nearly
page, right?
$3 million difference between submitted and confirmed figures, and I was just curious if we have more information about where that $3 million is. Little more than $3 million.
Okay, can you see the slide now? Okay.
Yeah, yes.
So let me give you a general answer, and then there are specifics contained within the report that we distributed to the committee, that AMI report. So what you'll see when you look at that report is that different documentation was considered to be part of a long-term capital commitment expenditure by Prospect than was considered by the monitors. So Prospect would offer up, for example, what they considered to fall within this category, and the monitors would apply, a different, a more stringent definition to what belonged in that category. So that's an example of the back and forth. And if you look at the report, you'll see that there's a great deal of back and forth. And that's why you have those kinds of differences. That's one reason you have those kinds of differences. I don't know if that answers your question.
Yes, I think so. Thank you.
Okay.
Other questions from the committee? Senator Costa.
Thank you, Mr. Chairman, and thank you, Ms. Weizenbaum. I have a question about what happens in this deal. I understand you can't speak too much on it until there's a final determination made, but specifically regarding the capital commitments and some of this stuff around the pensions. If a new struck, does that erase and give any new owner kind of tabula rasa on whatever was inherited from before, or is there a certain amount of money that's still expected in terms of capital improvements, and could a previous pension commitment be included in a current deal?
Let me make sure I understand your question, because I lost a few of your words there. But the capital commitment has been concluded. So there's not more money left on the capital commitment. And in terms of, and tell me if this is responding to your question, but in terms of looking back at the 2014 transaction and what relevance it has to the current transaction, because it's the same party, we don't have literally a new owner coming in. Their adherence to the previous conditions and their, conduct, for lack of a better word, in between the last transaction and this one is part of what's taken into consideration. Does that answer you? Okay.
Other questions from the committee for Miriam? So Miriam, I have another question unless somebody else has their hand up. With regards to the $62 million in capital commitment, building on Senator Acosta's question there, I've been reading about this for a couple months now, and I'm a firm believer, depends upon what I read, I'll probably get more confused of what I just read the prior 2 or 3 times than what I'm reading currently in front of me. But one of the, so we hired AMI to do, was it AMI to do the analysis?
Yes.
Okay. How much did we pay them to do that? And who paid for that?
Good question. So, is there still feedback, Jamie? Sorry about that. I don't know why that's there. So the monitor under the Hospital Conversion Act is paid for by the parties. So they put that bill. I do not know what that bill was, but I can certainly get that if that's of interest. They pay for that the way they pay for experts that we retain.
We don't need that tonight. If you can provide that in the next couple of days, that would be good. So the work that AMI does is for the state or for the party that's looking to make a change?
It's for the state.
Okay. So the state contracted with AMI to do the work that they did?
Correct.
Okay. In looking through some of the long-term capital commitment that's included in there, we include, there's like $3 million of software that is a part of that. I'm not certain I can, from my perspective as a legislator or my background in other areas, I would include software as a capital expenditure, long-term, not, it's capital. Long-term, I'm not certain how long-term it is, but in reading through the various documents that your office provided, others provided, those that are out there that you can, if you just Google the topic or search for the topic under any other means, you find a voluminous amount of information on every side of the story. And then you have to go look at who wrote the story, what's their background, and try and balance that. But it appeared to be there's some discrepancy in, and I don't have it in front of me, I just, like I said, the number of documents I read over the last N number of months make your head spin each time you read one, because you got to go back and forth and say, okay, this said this, that said that. As an engineer, the numbers didn't add up necessarily on one side or the other based on, time was in there as well. Do we consider software to be long-term capital from a state perspective?
I will myself have to go back. I know that software was included as part of the quote capital commitment. But remembering that there are 2 parts to the capital commitment. One is routine and the other one is non-routine. And I don't recall which, in which, maybe Jessica knows, into which the software fell.
And what's the split between routine and non-routine? Or routine and cap? If you don't have it today, that's fine, if you can get that to us.
That's what was up on that slide is, if you're asking like what proportion was routine and what was non-routine.
So I have that here, but, so I thought the $63 million number included software, but maybe it didn't.
I'll check that I'll check it quickly while we're during the hearing, yeah.
Okay. So I have some more questions, but other members of the committee with other questions? Okay, if we go back to the charter again, the Attorney General criteria. With regards to for-profit, And obviously, everything you do needs to be based on facts and data, people testifying under oath, et cetera. There's been a lot of things written out in the public there. There are times not certain what to believe, because you could pick up the same topic and two different people writing about it, and you hear two different answers. So with regards to the transaction you're undertaking now, the first question, you've accepted the application, so your 120-day clock has started, correct? When does your 120-day clock expire?
Well, it has expired. I mean, it began in April, right? Because that's when we deemed the application complete. So we have just extended that, and the parties have not objected to that. Obviously, the application was accepted, just a month into the pandemic, which significantly affected the ability to do all kinds of work.
So you've extended it to when, Miriam? What's the new date?
There's not a current end date.
Okay, so you went back to the parties, and I guess the parties here would be Ivy, and then Lee and Topper. Are those the parties?
Well, they're all the parties that are listed in that caption. So it's Prospect Medical Holdings, which is under Ivy and owns the different hospitals. And then if you go again all the way down that chain of ownership, it's to Prospect CharterCARE.
Okay. Do you think you should have a different set of criteria compared to what you showed here? I can't tell what page 12, 13. I can't tell what page number this is because it's...
I think it was 11.
I think it's 10. Maybe 10. The one with the Attorney General in the 6 boxes. Governance, conflict of interest. Should there be a different set of criteria that you'd look at here from the perspective of what's looking to occur potentially? And I'll say this with regards to the, what I wrote down earlier in my notes of reading this over the last couple of months is the word solvency comes to mind. Is the entity solvent? Forget about everything else for a minute. Is the entity solvent in what they're looking to do? And I think you did that with regards to the challenges that we're facing Roger Williams and Fatima and the challenges there that they had. How does solvency play itself into the mix, or the financial health, the financial situation, good, bad, or otherwise? I'm not casting dispersions one way or the other. How do you factor in the financial health of an organization looking to go through and accomplish the HCA based on the application that's been submitted?
So to your question, yes, solvency is part of it. The way I read the Hospital Conversion Act, and I think you can find that again most succinctly stated in Section 28, where it's specifically 28, not to be all lawyerly, but 28C is the provision that specifically concerns conditions to be applied by the Attorney General. And that's the reference to investment to protect assets, financial health, and well-being of the new hospital. Okay.
I have one or two other questions before I do it. Any other questions from committee members? Okay. So with regards to the report that AMI provided, and they provided some interim reports along the way, and I think you gave us some of that as well, I think. I'd have to go back and check. Does the AG's office evaluate that on an ongoing basis? And I realize this isn't yours. This baby was someone else's baby several years ago. Is that something that the AG's office would have reviewed on a regular basis as interim reports came out, provided feedback back, et cetera?
So yes, there were So the particular history with this includes not only the 3 annual, or let me back up a little bit. The conditions that were imposed on the hospital required annual reports for the 3-year period. So quick math, 3 annual reports. There were 3 reports delivered, but the 3-year period was extended to a 5-year period of monitoring because of the additional money coming in through sale of hospitals. So the monitoring was extended for 3 years. And the our office looked at each of those reports. In addition, this office requested some additional interim reports at the beginning. This is back in 2014, and reviewed those. Now, part of this does fall in our lap. So this final report that was submitted to the committee was the result of a report from Prospect that this office received in June, and then went back and forth with the monitors to press for the complete answers that the monitors and we felt were necessary in order to fulfill the monitoring obligation. And so, yes, we're involved in that process because ultimately the monitoring is done under the statute, and we are the enforcers of the statute.
Okay. One other thing with regards to the questions by the committee. One of the questions with regards to solvency. So I want to go back and ask the solvency question again in light of the pension question. So we're not going to talk to pension specifically, but in generic fashion, whether solvency is an appropriate word to use there, some can defer, will say it's not. I'll say it is for right now, for this discussion. The analysis that was done, I think it leaves a lot of questions unanswered from back then. Or if what they found was what they found, then either the information provided wasn't all there, or the information that was provided and the analysis that was done wasn't all there. Or somewhere in the middle, both of those. How do we reconcile? The concern and fear in all this is at the end of the day, because we're talking about a hospital, right? We're talking about, at the end of the day, it's access, it's quality, and affordability. Access, quality, affordability. And then tied to that are, for the patients, right? That's who we're most concerned about. So we never want to lose sight of who uses the services from an access, quality, and affordability perspective. But then when we're transferring control, we have workers that are there, that are tied to that for a variety of different things. And I know reading some of the different reports talked about size reductions and increases in different things as time went along based on some other conditions that might have been in place. But I guess I'm a little, reticent with regards to the process that we have for evaluating the change that's in front of us now. So have we learned from what's happened in the past and looking at this application in front of us now that we've had for a year, that we have the right protocols, we have the right measures, we have the right metrics, we have the right tap points in place to whatever decision gets made in the end. It's based on the facts and the data in light of what was done 7 years ago in 2014 regarding the pension piece. Like I said, I'm not talking about pensions per se, but that's the other piece. Access, quality, and affordability for the patients. But we also have workers there who have a vested interest, and there's an expectation of what they've been given and expected to be given. And if our process isn't robust enough to have articulated and discovered this issue back in 2014 to the degree it had, do we need to change our process before we say yay, nay, or yay with conditions on the current applications? What are your thoughts?
I think again, you're asking about with respect to the current transaction under review. And again, I need to be careful because I really don't want to express conclusions about that when it's
So I'm not
still
asking.
in play. But I think that, your question is the current process adequate?
Sorry, go ahead. And the reason I say that, Miriam, and please, if I'm wrong, please correct me. If what we discovered in the previous, what manifested itself after that, didn't come to light until after the fact, either the information provided was incomplete, the analysis was incomplete, or a combination of both. We don't.
Right. Or the tool wasn't good enough. And I think that's fair, right? Either, the tool's good enough, but there wasn't the right information. The tool's good enough, but it wasn't used well, or the tool wasn't good enough.
Right. It's one of only three options.
I think
The information provided wasn't appropriate, the analysis that done was inappropriate, or a combination thereof. So it's got three states: -1, 0, or +1. Pick one of the three from a mathematical perspective or a logic perspective, and that's where we are. So, okay. Other questions from the committee? Okay. I'm sure some of us will go back and look at the 276 documents that are there, and most importantly, we're going to look at what's not there, right? Why is something not there? And that question will get asked. And if you can, so here's the one last thing. Miriam, I'd be remiss, and I'd call you tonight and say, I forgot to ask you this question, so I'm going to ask you now. As part of the process in 2014, part of the current process, how do you evaluate what rating agencies say or don't say? How is that input used as part of the process?
Well, first, there's a decision as to whether or not it's relevant, right? So
Say that again, sorry?
whether a particular rating is relevant. To what is it relevant? That's the first question. And then if it is relevant, then you put it together with the rest of the information, right? So ratings on quality are relevant. Ratings on financial condition are relevant. Mm-hmm. And then looking underneath to see which ratings are which ratings are reliable for this particular circumstance, which are not. Some ratings are lend themselves to hospital systems, others don't. But I'll also say that you've got ratings, right? But then, the job of a state regulator, which is the role that the office is playing in this transaction, is to decide, I think, what are the standards for us? So ratings may be relevant to that, but ultimately, what is the standard for us? And when we're asking the question, is this investment sufficient to protect the assets, financial health, and well-being of this new entity? That sufficiency question should be with respect to what we expect and demand in the state. And that may or may not line up with an external standard or rating, because there are particulars in this state. These two hospitals play a particular role. They don't just treat patients. They treat people in the Silver Lake neighborhood, in North Providence. So when we are looking at the sufficiency of the company, in this case PMH, to continue with that investment to protect the assets, financial health, and well-being of the hospital, we'll measure that against the standards to which we will hold them as an office in Rhode Island. I don't know if that answers your question.
It does. I guess I know my role from a legislative perspective in oversight, right? We pass laws and we do oversight. This is an oversight hearing. With regard to just trying to, I appreciate your answer, try and understand, ascertain when we can choose to use what's out there or not, whether it's Moody's, whether it's Standard & Poor's, you name, whatever rating agency does what they do. We, the state, are judged by that every day, right? All of our 39 cities and towns are judged by that every day based on how much they have in undesignated, unreserved fund balance, et cetera. What do they have for the median income in their city and town? All those measures make a difference, because at the end of the day, the better rating, the lower interest rates you have on whatever you go after, et cetera. But I just ask, since we're looking at this from within the context of for-profit to for-profit. Not-for-profits is a whole different story. But for-profit, those factors should apply there as well with regards to how well are they, how solvent are they or not. But clearly looking at this from a for-profit to for-profit, transitioning and buying out this partner to acquire that partner, what else is should be addressed? I guess I'd ask you to think about, and like I said, I can never tell you what to do, and I won't tell you what to do, and we can't tell you what to do because only what's in the law is what you go by. I'm just seeking to understand, how do financial disclosures or financial ratings factor into the conversation? So, okay, thank you. Any other questions for the Rhode Island Attorney General's office? Miriam, thank you very much. If you want to stay around and listen, we welcome you to do that, but thank you very much.
Oh, thank you. No, absolutely, I'll listen. And I also just wanted to let you know, Chairman, that the software was, just to answer that question, the software was included in the routine expenditures and not in the long-term capital non-routine expenditures.
Thank you very much.
Close that loop. Okay.
Thank you.
Thank you. Thank you for the opportunity.
Thank you very much for being with us. Next, I'd like to call up Chris. Well, not call up. Chris has already called us. Chris Kalachi, Esquire, General Counsel for United Nurses and Allied Professionals. So folks on the committee, both for Chris and for Jeffrey, they'll be talking to us. There is not a presentation, so Chris, we'll go over to you on the agenda.
Thank you, Mr. Chair. Am I being heard?
Yes.
Good.
And we can see you as well.
My condolences. So, Mr. Chair, thanks for the opportunity to come before you and members of the committee. I do not have a PowerPoint presentation. I think Miriam and Jessica did that to make me look bad. But I did share some reading materials with the chairman, and I believe he got them to you. And much of what I'm going to say is supported by documentation that he has, that he can provide to you if you want it. I did not want to overwhelm you with documents. There are volumes of documents on this subject matter. As you have heard, there were 30 conditions attached to the HCA approval of the Prospect CharterCARE deal back in 2014. And I've been asked to speak to those conditions and the resultant commitments that came from that. So there's been some talk already about the St. Joe's pension situation. Let me tell you that there were 3 conditions that were attached to that approval in 2014 that were relevant to the pension, the St. Joe's pension. One condition required that the transacting parties implement their application as they presented it to the regulators. In other words, they were supposed to do what they said they were going to do in their application. That was one condition, and it is relevant to the pension. There was a second one, and that is that they weren't going to do what they said they were going to do. They were supposed to notify the AG of the case, that there was going to be a change. That was another condition. And there was a third one that was specifically designed to address the St. Joe's pension plan. And they were supposed to notify the AG of any actions out of the ordinary course or material changes in the operation or structure of the St. Joe's pension plan. So 3 conditions spoke to the pension. Now, here's what Prospect told the regulators. Here's what the transacting parties told the regulators. They said that they would put $14 million into the St. Joe's pension plan, and they said that that would secure the plan. And the second thing they said was that contributions would be made going forward based on the recommendations of the actuaries, and that those contributions would be made by St. Joe's. That's what should have been implemented, meaning a contribution to the plan to secure it and contributions going forward based on what the actuaries told them they had to put in so the benefits could be paid out. Now, if any of you have paid any attention to the lawsuit that's pending in state and federal court right now with regard to the collapse of the St. Joe's pension plan, here's what you will know. You will know that Max Wistow, the special counsel who brought that lawsuit, has alleged, and I think the facts support it, that one, when Prospect said that the $14 million would secure the plan, they knew that it was $91 million short. That means they knew that the $14 million was not going to secure the plan. That's number one. Number two, it is alleged that they knew that St. Joe's did not have the financial wherewithal to make the contribution to the plan going forward based on actuarial recommendations. Now, what's important about this is that they didn't implement the way they said they would with regard to the pension, vis-a-vis the $14 million and the contributions going forward. They did not notify the AG, as far as I know, that there was a change and that wasn't going to happen. And they certainly didn't let the AG know, as far as I can tell, that no contributions whatsoever were being made when they had an obligation to do that, and that there were material changes in that plan and in its operation and structure, and they did not notify the AG. Now, if I do my math correctly, that means those three conditions were not satisfied. I want the committee to be aware of that. Let me shift gears to a few other conditions on top of that that were not satisfied as far as I can tell. One condition required that the transacting parties provide the Attorney General with copies of any notices that they got out of the ordinary course of business from, for example, CMS. CMS is the Center for Medicare and Medicaid Services. And a second condition related to that required they notify the Attorney General of any complaints from either state agencies where they operate hospitals, Rhode Island and other states, or complaints from, again, CMS, the Centers for Medicare and Medicaid Services. We don't believe they satisfied those conditions either. So, for example, if you read the ProPublica article that I gave the chairman, and I believe he shared with you, you will know that back in California sometime around 2015 or so, there was serious back and forth with CMS about improper Medicare billing. And in particular, there was a potential for roughly $23 million worth of improper charges charged to Medicare and Medicaid. We know that CMS was notified about that. We know that CMS audited that. We know that Prospect made some repayments. And as far as I can tell, they didn't disclose that at all, which was a condition of the approval back in 2014. I don't believe they disclosed that to the AG. If I'm wrong, Miriam or Jessica will tell you that. I don't think that they did. Also back in 2015, also involving a hospital out in California owned by Prospect. The State Department of Public Health and federal investigators from CMS shut down a surgical unit in one of their hospitals for 8 days. Shut it down, no procedures. And that was because there was an immediate risk of widespread infection. I want you to think about that for a minute. There was such a high risk of infection in that particular surgical suite in that particular hospital owned by Prospect, they shut it down for 8 days. I am pretty sure that Prospect did not notify the AG of that either. And those kinds of CMS matters should have been reported under the conditions of the approval in 2014. And I don't believe that they were. There are other conditions that were attached to the 2014 approval that I do not believe were satisfied. transacting parties were required to report annually to the AG on the funding of the capital commitments. 50 million long-term capital commitments, 40 million in routine capital commitments. I thank the chairman for raising the issue of the $3 million worth of software, and I'll come back to that. If I forget, Mr. Chair, remind me to come back to it. But that commitment, that set of commitments, those tens of millions of dollars under the approval were supposed to be made within 4 years of the approval. The approval was issued in May of 2014, which means by that time, 4 years later in 2018, and certainly as I can gather, no later than June of 2018, those capital commitments should have been satisfied. And I believe that Miriam had said during her part of the testimony that they weren't satisfied until sometime in 2019. The monitors, AMI, didn't confirm, as far as I can tell, until December of last year, 2.5 years after those capital commitments should have been satisfied, that they didn't report and confirm that they had been done until December of 2020. That's when their report came out confirming that. That means to me that the conditions to have made those capital commitments by June of 2018 were also not satisfied. Now, let me touch on the AMI figures I think that Jessica put out there. I would respectfully submit to this committee that there are questions of credibility associated with the work of AMI. And the reason why I say that is our regulators who are currently reviewing the current applications and transactions have gotten a number of objections from a number of parties, some from me, some from Mr. Wistow. And he has filed an objection, which I shared with the chairman, that raises a number of questions about the work of AMI that are troubling to me. He would know more about it than I. I hope you bring him before the committee so you can ask him some questions. But it's my understanding that AMI was contracted to produce roughly 10 reports, and I think they reported 3. If I'm wrong, Miriam will correct me, or Jessica will correct me. But I don't think they produced all the reports that they were supposed to produce. They produced 3. They produced 1, as far as I can tell, in June of 2018. And then they produced another one in March of 2020. By the way, in neither of those first 2 reports could they verify that the capital commitments had been satisfied. With respect to the first report, that was issued in December of 2018, which was 6 months after they should have been able to confirm that the capital commitments had been satisfied in June of 18. The other thing that I think is really important here, and this goes to the $3 million of software, and Max Wistow raises this in his objection, and I hope you take a look at it. Because it goes to whether or not these conditions with respect to capital commitments have been satisfied. There were very specific criteria in the asset purchase agreement between the transacting parties, Prospect and CharterCARE Health Partner, that required that not just any old expense qualifies as a long-term capital commitment, right? That just makes sense. And there are criteria. So, for example, if you look at the asset purchase agreement, it says that there has to be an explanation that these commitments are relevant to facilities and equipment. There has to be an analysis of whether or not there was a material needs assessment, meaning that those commitments, those financial commitments were needed, right? If you're spending money on stuff you don't need, it doesn't help you. And there are serious questions have been raised about whether or not that $115 million that was on a slide a moment ago, that those capital expenditures actually qualify as long-term or routine capital commitments. And that's an imperative. That question has to be answered. You can't say that the transacting parties and prospects satisfied those conditions unless you can say those expenditures qualify. Hence the importance of the question that the chairman asked about the $3 million in software. So I don't think that that's a question that has been, or those are conditions that have been fully satisfied. The chairman also, in his invite to me, asked me to speak to other pertinent topics. and then ask me to shift gears and speak about my insight and my concerns about the pending application. Let me raise some pertinent topics with you that I think ought to raise your eyebrow and ought to raise your radar, because this is what has happened since 2014. Since that 2014 HCA approval, Prospect has borrowed in the neighborhood of $1.15 billion, with the B as in boy. After having borrowed that money, they dished out nearly $500 million in debt-financed dividend payments. Over $220 million of that went to Mr. Lee and Mr. Topper. Those are the two gentlemen who want the AG and the Department of Health to give them 100% interest in Prospect Medical, which means 100% interest in our local hospitals. When that was going on, Moody's downgraded Prospect's ratings because they were alarmed at the level of debt they were taking on. I don't think it's a coincidence that subsequent to that, I think in terms of the timeline, Prospect then turned around and sold much of their real estate and their assets to an organization called MPT. And somebody will have to help me with, I think it's Medical Properties Trust, in a sale-leaseback agreement. Here's what that means. That means I sell my property to you and I lease it back. That way I can get the equity out of my property and I can start paying off some of that debt I incurred by making almost $500 million in a debt-financed dividend payment. Does that sound cool to you? Because it doesn't to me. Now, Mr. Wistow had a CPA and consultant, Don Weishart of Weishart CPAs and Consultants out of Kingston, Rhode Island, do an analysis of this and the financials. I believe that the chairman has shared that document with you, so you have it. And if you don't, I'm sure he can get it to you. It's a public document. It's been filed in the regulatory review that's ongoing right now, and he is saying that Prospect is facing imminent bankruptcy unless there is a serious infusion of capital and a return of all the dividend payments. Now, that is not heated rhetoric. That is not me speaking. That is Mr. Weishart. So I think you have to consider that. And the last thing I'd say in terms of pertinent topics before I get to the pending application is the Wall Street Journal ran an article not too long ago. And I believe that I've given that to the chairman. I think he can provide it to you if he hasn't already. And they describe these situations where private equity is being used to buy hospitals, then the assets are used to borrow money to make debt-financed dividend payments. And I'm quoting from their article, which says that some of the most controversial debt-financed dividend payments in recent years are the ones associated with Prospect Medical. Now, when you look at that stuff as a whole, I would submit to you that we all better be really nervous about what these guys are doing and what they're going to do if they get 100% interest in these two local hospitals, which are safety net hospitals. I'm going to shift gears now to insight and concerns on the pending HCA application. And I'm going to be right down the middle on this. It is crystal clear to me, and it is in my opinion, back in 2014, Prospect intentionally misled the regulators with respect to the status of the St. Joe's pension plan. They misled the regulators with respect to the impact the $14 million would have, and they misled the regulators with respect to contributions being made going forward. And I would also submit to you, and I said this in writing, and these are public objections I filed in the CEC and HCA process pending now. They are misleading, intentionally misleading our regulators again. Here's what I mean by that. Whether it's an HCA or a CEC review, the criteria that apply to those reviews include having to review character of the applicants, their competence, their commitment to the community, their standing in the community. And they fill out their applications in the CEC process. They were required to identify and describe for every one of their affiliates Every one of their hospitals, and they don't just have hospitals in Rhode Island, they have hospitals in New Jersey, Connecticut, Pennsylvania. They had them in Texas until they closed them. California, to name a few. They were supposed to, in that application, these current applications, disclose any citations, enforcement actions, violations, charges, investigations, or similar types of actions, including but not limited to actions brought forward by any governmental agency, accrediting agency, or similar type of agency. They were also required in their application to disclose not just for their Rhode Island hospitals, but their affiliates. Identify and describe all civil proceedings, whether pending or which have resulted in a disposition or a settlement in any court of law. Whether it involves their hospitals in Rhode Island or their hospitals in these other states, they have withheld an enormous and disturbing amount of information from our regulators. And it is a matter of public record that I've been specific about what they've withheld, and I've asked the regulators to take a close look at this because it's centrally relevant to their review of these applications. And I'm going to give you a little flavor. I'm going to give you a little bit of a flavor of the kinds of things that they've withheld, because I don't think it's a coincidence that they've withheld it, because if they disclosed it, it doesn't make them look very good. So here are a few things that they have not shared with our regulators. Multiple pending lawsuits at their hospital in Culver City, California. This is Prospect now. Alleging fraudulent billing of Medicare and an illegal patient procurement scheme designed to generate fraudulent Medicare and Medicaid claims. Now, all this stuff is in the article that I gave you from ProPublica. And Prospect tried to say that it was not credible reporting. Let me remind them, and let me tell you, that this is a 5-time Pulitzer Prize-winning publication. The 2018 state inspection at the Culver City Hospital that uncovered the dispensation of about 21,000 doses of adulterated drugs over a 9-month period, resulting from fungal air growth, bacterial organisms, and mold and equipment used to mix patient medications. 2019 charge of gross negligence made by the California Attorney General against Mr. Lee and others. That was pending at the time the article ran. The article ran in October of last year. The 2018 immediate jeopardy finding of Prospect's Manchester Memorial Hospital in Connecticut involving the mishandling of 2 high-risk pregnancies, one resulting in the death of a patient. The 2019 finding that Prospect Waterbury Hospital in Connecticut had failed to monitor 2 suicidal patients, resulting in the death of 1. An initial denial of Waterbury Hospital's accreditation by the Joint Commission, finding 42 standards were out of compliance. And in December of 19, Connecticut regulators extended the monitoring of Prospect's Connecticut hospitals until May of this year. A 2018 finding of an immediate jeopardy in the mental health ward at Prospect's Crozier Chester Medical Center in Pennsylvania. And then a number of other things that were a problem in Waterbury Hospital in Connecticut, where they faced the steepest fine of any hospital in the state by the federal government for high reimbursement rates. Also in Waterbury Hospital, losing accreditation, facing losing it, that is, because of there being 43 areas of deficiencies. And then in New Jersey, East Orange General Hospital, they got an F by a national hospital watchdog, the state's only facility to get one. This is the kind of information they were required to share with the regulators, and this is the information that they did not share with the regulators. Those are the out-of-state hospitals. Here are some of the things they didn't report on the in-state hospitals. Roger Williams and Fatima had a 1% reduction in their Medicare payments in 2018 by CMS. Why was that? Because they ranked in the lowest 25% of 3,200 hospitals in the United States that were surveyed with respect to rates of infection. I'm involved in a case that's currently pending in the First Circuit, where they were found to have violated federal laws because they wouldn't disclose information about 30 deficiencies that were found by JACO in a survey of Fatima Hospital, and a mock survey that found all sorts of problems including operating room instruments being contaminated with foreign materials. The judge told them they had to give the union that information, and we're now in contempt proceedings in the First Circuit because we still don't have it all. They didn't disclose that to our regulators in this pending application. I had a case that went to the federal district court in the District of Rhode Island because Prospect decided they were going to take the dental and vision benefits away from the spouses of employees. These are the employees who are taking care of COVID patients at the hospital. These are guys who have collected hundreds of millions of dollars in dividend payments, and they can't honor a contract that requires they extend vision and dental benefits to the spouses of employees. This was not disclosed to our regulators. So the list of these things that they've not disclosed has gone on and on and on. And it's a real problem in terms of the current review that's going on. Here are a few others that were unearthed in the ProPublica article. Instances involving the failure to pay bills. This is Prospect now. Changing vendors to avoid payments, slow-walking vendor payments, bouncing checks, placing hospitals in bankruptcy, putting out aggressive financial statements to make the bottom line look better, hiking reported profits by booking inflated estimates of forthcoming revenue, closing hospitals in Texas, laying off 1,000 people when they said that they would keep that system there. On and on. So, I've taken some time to look at their responses, questions that were posed by the Attorney General's office in this current pending application. Now, a lot of materials have been deemed confidential. So, still have you? Do I still have you?
You do, Chris. Keep going. You're good.
Okay.
Yep.
So when I read the answers, there were some redactions. There are some documents that are not public. So I will tell the committee that what I'm about to say, there may be some challenges to that from Miriam and Jessica, because but it looks to me like there are a series of core questions that they have been answered that they're dodging. Here's some of them. They're dodging questions about those dividend payments I've been telling you about. And their answers seem to say that the inquiries about the dividend payments are not relevant. Of course they're relevant. They're dodging questions about the sale-leaseback agreement I told you about. And there was one question about whether or not equipment at our hospitals in Rhode Island will be subject to a sale-leaseback agreement. And they're saying, well, at the time, we don't really have any plans, but the answer is equivalent. They're dodging questions about explaining why they closed the hospitals in Texas. Our regulators need to know why, because I got to worry about whether or not they're going to close hospitals in Rhode Island. This one's really disturbing because it echoes what happened in 2014 with respect to the misleading nature of their representations with regard to the St. Joe's pension plan in 2014. You would think that they would have learned their lesson in 2014. They got sued here because of what they did in that regard. They just cut a check for nearly $30 million to settle that lawsuit. But there were three questions that were asked and posed by the Attorney General about the 401k that employees have at the hospital. And none of those questions were answered directly. In fact, they were dodged. They dodged questions about how they calculated the purchase price. These guys are going to buy out a 60% interest held by Leonard Green in a 17-hospital system for $12 million? That sound right to anybody? Don't our regulators deserve some explanation for where they got that number from? And it also has become apparent in the review process that in terms of that 50-50 board that Jessica talked about in the approvals in 2014, the 4 board members who were appointed by CharterCARE Health Partners were completely frozen out of this particular transaction that is now being reviewed by the Department of Health, Health Services Council, and the AG. Think about that for a minute. Mr. Lee and Mr. Topper have come to our regulators asking to gain 100% control of our local hospitals, and the 4 members of the board who should have had an opportunity to learn something about that transaction were frozen out of it. Where do I get that from? It was public comment period, and the lawyers for those board members testified, and the transcript is available. I gave it to the chairman. So, here's what I would close with, and then I'll answer any questions that you may have for me. In terms of process, the Health Services Council may be a public body, but the statute says that they are supposed to consult with the Director of the Department of Health on transactions. They are supposed to advise. They are supposed to reach findings and make recommendations to the Director so that the Director can make an appropriate decision about whether or not to approve an application. You cannot, the Health Services Council cannot do their job. They cannot consult, they cannot advise, they cannot make findings, they cannot make recommendations if they're reviewing an incomplete application, which, by the way, a complete application is required by statute. And by leaving out all the information that I just went through with you that should have been and was not in their application, the application is not complete, so the Health Services Council can't do their job. That also undermines the public comment element of the statute. How can the public comment on an application that is not complete? They cannot do it. It is an impossibility. So we've asked them in written objections, and I want the committee to know this, I have submitted objections saying, look, Health Services Council, you need to deem the application incomplete. You need to make the applicants provide all this information that they were holding from you, and you need to reopen the public comment period. If you don't do that, whatever findings you reach, whatever recommendations you come up with are not going to be worth very much, and you will be depriving the public of a meaningful public comment, which would be a violation of the spirit and the letter public comment period in the statute. I would also say that I think that AMI fell down on the job. I don't think they did the job that they should have done. And if they're not monitoring, then it's really difficult to enforce conditions. And if you can't enforce conditions, then what's the point of attaching them to an approval of an application? What's the point of having all those conditions if there isn't appropriate monitoring, which then deprives regulators of being able to do the enforcement? So, you know, going forward, I'd like to at least see there be some better monitoring. And another issue that I would raise is, and I have raised this in my objections, I know Miriam and the General and Jessica have given some thought to this. I would like there to be, and I think Chairman DePalma, you may have raised this, I think there needs to be some loosening up of the confidentiality determinations. I think there needs to be more sharing of documents with the public. I think there were documents that were recovered in Max Wisto's investigation of the St. Joe's pension collapse case, documents he subpoenaed from prior administration in the AG's office, AG Kilmartin, that revealed that there were things that should have been disclosed that weren't with regard to the pension that I really sure wish I had access to as the lawyer for the union back then. And I didn't. And that's a travesty. So I hope that the confidentiality stuff is relaxed. The other thing I would say to you is that if we don't tighten this process up, applicants like Prospect are going to feel like, hey, you know what? We can submit an application. It won't be complete. We'll get away with it. If there's an approval, maybe there won't be really, concise and appropriate monitoring. Maybe we'll get away with some stuff in terms of enforcement. Not a good message to send to those folks who are coming to our state to buy our hospitals. And the last thing I would say, and then I'll yield to the committee, is as far as I can count, there are 3 pending pieces of legislation that have been sponsored in the Senate that all get to the Hospital Conversion Act. The Senate President, and I did a joint public opinion piece with him on this, the moratorium bill, calling for a moratorium on any more for-profit transactions. We wholeheartedly support his effort in that bill. Leader McCaffrey has a bill to change the Hospital Conversion Act, which would require much more regulatory insight and review into staffing levels that would come out of an approved transaction. And I can't applaud Senator Oyer's work enough in a bill that she has sponsored that also requires staffing disclosures, quality measure disclosures, like, for example, applicants having to make JACO surveys and deficiencies that were found public and available to regulators when they do their reviews. Disclosures for the regulators with respect to preserving jobs, benefits, so that pension collapse doesn't happen again. And this is really important. Penalties for applicants who lie to regulators. Penalties for applicants who intentionally mislead regulators. Her bill says if you do that, your applications are summarily rejected and you are banned from doing a transaction in the state for a period of time. If we don't have those kinds of teeth in the legislation and the act, I think we lose an opportunity there. So in terms of what we might do better, I'd like to see the elements of those bills put into something meaningful that becomes law so that our regulators have the tools they need to do the job they need to do. And last plug is that I hope that the state allocates the money that's necessary, give the folks at the Department of Health and the Attorney General the money they need, the resources they need, the staff they need to do this job, because it is an important job. They are the gatekeepers to healthcare in our state, and they ought to get what they need to get to do their job. Thanks for your time. Any questions that you have, I'll do my best to answer.
Chris, thank you very much, and thank you for being as thorough and comprehensive as you have. Wouldn't have expected otherwise. I have a few questions. Questions by the committee before I start? So, Chris, one of the, you certainly have given us many things to ponder, many things to go back. With regards to, and I'm sure I'll ask Mr. Liebman when he gets up next about this, and Miriam, if she's still on. Is Miriam still on? Maybe some question. Miriam, if you, probably better.
Yeah.
So Miriam, Chris brought up the notion of, I say this respectfully, the notification of certain conditions that, of the 30 conditions that should have been reported. So he brought up several of those. I'm not going to ask you to go through each one of those, but conditions and situations that manifested themselves in other states, whether it's with CMS or whatever, were those expected to be reported to Rhode Island?
So what I can speak to is the obligation to report under the initial conversion in 2014.
Yes.
And what I don't know is whether I think each of the CMS notifications that Attorney Kalachi referred to occurred after that 3-year period that the decision refers to. So each of those conditions required Prospect to report certain things within this 3-year period, and that 3-year period was set by statute. It's been expanded to 5 years, which is exactly, what needed to happen. But I believe that those occurred outside of the 3 years. But in any case, again, that occurred under the previous. If they did occur within the 3 years, that was within the previous transaction. As to the implications of any of that for the current transaction, that really gets into the specifics that
Got it. Okay.
my office can't speak to.
So stay there for a minute. Don't go away, please. With regards to that, though, I think we heard you mention, I think we heard the AMI piece mention, and Chris mentioned about the commitment of capital. I expected that was 3 years as well, right?
No, that was extended. An additional 2 years were added to that. So there was.
But initially it was the 3 years, correct?
Correct.
So we extended one piece, but we didn't extend the whole piece, the whole thing? We had other conditions that were only 3 years, but the conditions for us to ensure the capital commitment, routine, non-routine, was extended without other conditions with the transaction.
Well, I think the conditions were altered somewhat too. And that's the reason why the capital commitment ended up being higher than what was originally contained within the decision. But basically, the time period was extended to allow the full capital commitment to be made. And whether they should have made it in the 3 years or the extension was a good thing or not, I don't have an opinion on that.
Okay,
That's just what happened.
So going forward from here, because one of the things I'm a firm believer in these hearings about gathering facts and gathering data and then figuring out what we do with that. Part of what we do is we have subsequent hearings. I already see something coming and we're gonna need to have a subsequent hearing about this. But the secondary piece is how does what we hear need to formulate itself into legislation? So, would it be I know you can't speak for the Attorney General, but I'm going to ask you to in this regard. Should we extend a application period? Shouldn't all the criteria go along with it?
I think those are two questions. I want to make sure I got each of them. Should the review period be extended?
No, I'm saying if something's, forget about the review period or I guess the conditions were set up for 3 years. We then extended the monetary investment 2 more years. We made that 5 years, correct? In doing so,
Just to be clear,
sure.
In the conversion, the condition that the capital commitment was to be made in 3 years, that condition was extended for 3 years. Then there's the statutory period over which the office can exercise control.
No,
that was originally 3 years. That was also changed to 3 years. So there are two different.
Agree, but we didn't add those other criteria along with it. That was only 3 years. The reporting in other states. So the reporting on the conditions associated with the investment was extended, correct?
In that particular conversion, it
Yes.
was extended to 5 years, yeah.
Uncle, in the future, should legislation be changed should any conditions change, all the conditions that are monitoring, not monetary, monitoring should go along with them. If somebody's getting the ability to do something over a longer period of time, shouldn't we expect and want the criteria by which we're going to expect the reporting things back to us of, we don't really care about the good things, we care about the bad things because that potentially affects us here in Rhode Island. Wouldn't we want those same kind of conditions extended? If we're going to extend anything, we extend the whole thing from a conditions perspective. Why do we pick just one area where it's a monetary investment?
No, the extension of 5 years for the money, for the capital commitment.
Yep.
That was specific to that transaction.
No, I understand.
The extension to 5 years in the statute applies to everything. So it has been extended to 5 years.
Agree, but that 5 years may get extended to 7 years at some point on something. Well, all I'm getting at is if we extend anything, let's extend everything.
And that's what was done, is it was extended, all of it was extended 5 years. Now, whether that's sufficient, I think.
Okay, I'll make a note. Okay.
Okay.
Senator Acosta, thank you.
Thank you, Mr. Chairman, and thank you, Chris. Do you prefer to go by Chris?
Chris is fine. Thank you, Senator.
Thank you, brother. So I have a question. I don't want it to be too nihilistic, but given what you presented and who you represent, what would be the best path forward? Because my read of this is that not allowing this sale or transaction or allowing this sale or transaction doesn't necessarily on either side alleviate the issues that we're pinpointing. And this is not just on you, or on this organization even. We've talked about before adding teeth to the HCA and what this could mean. In some ways, there's a side of me that says, well, authorizing a sale could benefit us because it could allow us to insert new conditions, given the kind of circle that we just went on discussing extensions on conditions and so on and so forth. So from your seat and based on the folks that you represent, what would be the best path forward?
Well, first I would say that it's really important that we strengthen the Hospital Conversion Act. And by the way, while we're at it, I would make some changes to the change in effective control statute. And I would also make corresponding changes to the regs. We need to be able to put, there should be a much stricter regulatory scheme in place to deal with, I'm just going to say it, bad corporate citizens like these guys. And for those who act in good faith, to make sure that we're really a lot more thorough in terms of understanding who we're dealing with and what they're going to do when they get a hold of our healthcare assets. So that's why I mentioned those three pieces of legislation. The second thing is notwithstanding your point, Senator, about if this is approved, we can attach additional conditions. Point well taken. Our position is that this application should be rejected because we've got guys who are going to get 100% interest in these two hospitals. And I don't believe, based on the statutory criteria, that they have the character or the competence or the standing in the community or the commitment to our community to deserve to have 100% interest in those two safety net hospitals, where the people who go there for their services are going to a hospital that they're running with the record that they have, and that the good people that I have the good fortune of representing who provide the direct patient care in that community have to be employed by people like that. Let me just say this, just 2 points of clarification on the back and forth between you, Mr. Chair, and Miriam. I want to say that the reporting on the CMS stuff absolutely occurred within the 3-year period. And I checked that very carefully before I testified before you tonight. So I think that Miriam was thinking that it may have been outside, and I think it was most certainly inside. That's number one. And number two, with respect to extending the deadline to make the capital contributions, I don't want the committee to view that in isolation. Prospect and CharterCARE went to the town of North Providence, and they went to the city of Providence, and they said, we're going to make these commitments within a 4-year period of closing. And because we're going to feel the pressure of that, we want $42 million in tax breaks. And they got it. So there wasn't any change in the terms of those tax stabilization agreements. You know, the city and the town, were they consulted about that by Prospect? I don't know. Maybe they were, maybe they weren't. But at least the town and the city, who have a 10-year phase-in tax stabilization agreement with these guys, would have said, well, if you want more time to put in the capital, we're going to accelerate the expiration of the tax treaty. So you're paying full taxes to the town and the city earlier than you were supposed to. Now, I'm pretty sure that didn't happen. Point number two on that is there was a lawsuit pending, it may still be pending, where CharterCARE sued Prospect. Imagine that. They're joint venture partners. Prospect owns 85%, CharterCARE owns 15%. The latter had to sue them because they were feeling like if those capital commitments were not made on time, they were opening CharterCARE up to lawsuits. So if we want to talk about the extension of the capital commitments beyond the 4-year period, beyond June of 2018, okay, beyond that, you can't look at that in isolation. Go ask the cities and the towns whether or not they had a say in that. Go ask CharterCARE if they had a say in that. I think the answer is no.
Thank you, Chris. Other questions from the committee? Chris, I had just two, I know you brought up the thing about the $16 million buyout. And knowing that, was it Ivy had 60%, I think, and Lee and Topper had 40% or thereabouts. And looking at the value of what they borrowed or whatever, I don't know how a $16 million buyout equates. It just doesn't seem like there's I don't want to say realistic, but 16 just seemed like it was, I guess, way too low for the value of the operating entity. It's a company. It's a business. Companies are in business for-profit companies are in business to make money. That's what the premise is. That's why you have shareholders. And I know I'll ask Mr. Liebman when he comes up next about that number as well, about how did $16 million come about and what their thoughts are. But what are your thoughts, real brief, because then I have a quick follow-up after that on that. Thoughts about the $16 million buyout?
Well, so first of all, Mr. Chair, I think the number's 11.9 million.
Okay.
And I don't get that number either. And to the Attorney General's office credit, I've seen them ask a series of questions about that. The public information in terms of the responses to those questions look like a dodge to me. But in fairness to the applicant, there were redactions, and maybe there are documents that our regulators have that are relevant to that number that the public does not have access to that would explain that. But
okay, I'll ask them when
it makes no sense to me at all.
Thank you. I'll ask them when they come up next. The last question, Chris, with regards to, and I've read through the plethora of documents out there, and the 3 sets were sent to the committee over the weekend to take a look at, and we have lots of information from yourself, from Jeff Liebman / Chris Vitale, from Prospect, as well as the Attorney General. So it's certainly going to give us more information, more facts, and more, I think it's facts and data to read and figure out what we do next. But regarding a next, and so I've read through several of the court proceedings and settlements. So one of those talks to who can talk to us and who can't talk to us. And I'm going to ask this question specifically for Jeff when he comes up next. But I think several of the folks you mentioned, from my reading of the cases that have been filed, or if that's even the right word, I'm an engineer, I'm not a lawyer. In order to bring in somebody like Mr. Weishart or Mr. Switzow, I think they've signed agreements that basically said they're not going to talk about anything unless they're subpoenaed or the parties allow them to speak. From your, like I said, I'll ask Mr. Liebman the same thing, and hopefully we'll be able to get them to come talk to us, because this won't be the end of the conversation. Is that your understanding of the agreements between at least Weishart, Switzow, I don't know who else, maybe Del Sesto or whatever, but.
There is a provision in the settlement agreement that says that they probably couldn't come and testify before the committee unless they were given a subpoena, and they could, or if Prospect doesn't have anything to hide, they can waive that part of the settlement and say, look, we want the committee to be fully informed, and we don't have a problem with those gentlemen coming before the committee, making a presentation and answering the questions.
Okay, I just want to make.
And they can do that if they want.
Thank you. I just want to make sure that's what I read. Like I said, I'm not a lawyer, I'm an engineer, but that's what I thought I read. Thank you. Any other questions for Chris before we move on? Chris, thank you very much. Thanks for the information you provided us. I'm sure we'll be getting back to you with some questions, some comments on some things you provided us, and then some. So thank you very much.
Thank you.
Chris, thank you. Next, I'd like to bring up Jeffrey Liebman, Chief Executive Officer for CharterCARE Health Partners. Jeff, are you with us? Hopefully you're still there, Jeff. Jeffrey?
There you go. Can you hear me now, Mr. Chair?
We can, yes. And do you go by?
Thank you so much.
Do you go by Jeff, Jeffrey? How would you, Mr. Liebman? How would you prefer it?
As my friends say, Jeff, or any 4-letter word is fine. But
okay.
Jeff is fine. Thank you.
We'll try.
Thank you for giving me the time to speak. I appreciate the opportunity to add a few facts and maybe clear up some confusion that might be out there. First, let me introduce myself. My name is Jeff Liebman. I have been CEO of CCHP, Charter Community Health Plan, Health Partners rather, since October 2018. And since then, I can be very, very specific and detailed about what's gone on in those years. I have more than 25 years experience running hospitals in healthcare systems. I've been in and out of the Harvard system for about 10 or 12 years. Also was in the Stewart healthcare system and was also in the Tenet healthcare system. So I have been in several systems and seen different systems that work, mechanisms, things like this. Primarily, I've worked in Massachusetts and Rhode Island. I'm a Rhode Islander. I raised my 2 daughters here, lived in the city for quite some time, and back again since I took this position. I was recruited back here. I'm here at the invitation of Senator DePalma. He has asked me to come and focus on the 2014 agreement, which will obviously go towards the initial $100 million investment here. The reason I say initial is because much more has been spent than that $100 million. A lot more has been invested since then here in Rhode Island. And also to give a brief discussion about the proposed transaction that people have referred to over and over again. As the good senator mentioned before, in 2014, Prospect acquired Roger Williams Medical Center, Our Lady of Fatima. As requested, I'm here to brief the committee with a short presentation focusing on the conditions of the 2014 HCA, the commitments, and additionally, I will provide an overview of the pending HCA and CEC applications that talk about buying out the private equity investors. Please realize those investors have been involved all along in some of the conditions and issues that have been raised before. So don't think that them coming in and out of this really changes some of that history. Let me first say that in order to put this in perspective, I think we have to talk about, in 2014, what was Rhode Island facing? And I think it's fairly common knowledge where these hospitals were. Before Prospect in 2014, these were distressed institutions. They were losing money, negative cash flow, decaying physical plants, some of which were really in horrid positions. The old emergency room at Roger Williams Hospital, I would say, was downright medieval because they didn't have capital to fix it. There was a shortage of doctors. Doctors were leaving, and that was leading to not being able to meet the community needs in many communities, not just Providence and North Providence, but Pawtucket and Johnston, and a variety of the areas that we currently serve. So let me say that the situation was not good. And honestly, everyone knew that if something wasn't done, these hospitals were going to close. It's simply that obvious. Where we are today is a completely different situation. We have met all of the promises and outlines in the 2014 requirements that we can go through in greater detail. We continue to invest beyond the original promises. We continue to recruit new doctors. We continue to provide, to bring innovative clinical techniques here. We continue to expand our workforce. These are good paying jobs, and we expand the workforce in both union and non-union positions, depending on the nature of the job and the campus they work on. We continue to serve the citizens where they need help the most. We are very proud of the fact that we've expanded our emergency rooms, rebuilt them. Believe me, our emergency rooms are not where we have the best payer mix. We're very proud of the commitments we've made to behavioral health. We have invested a great deal. In fact, we've opened the only behavioral health emergency department in the entire state. And we continue to support several charities in the area. And if you want to know where we're going, it's very simple. We're going to continue to expand our clinical programs and services. We are going to focus on healthcare operations and innovation. We anticipate that the pressure on hospitals is not going to get any easier. We don't think there are going to be increases in fee schedules to hospitals. Therefore, we have to be as strong and as smart and efficient as we can be while continuing to provide high-quality care and bring innovations that we've learned from other parts of the country here to Rhode Island. We are also looking forward to 100% of control going back to experienced healthcare executives, people who are dedicated to serving this community, and people who understand the local needs. I have never met anyone from Leonard Green. No one from Leonard Green has ever called me or come to Rhode Island. So the idea that Leonard Green leaving somehow affects the ongoing operations of the hospital, to me, is a little bit absurd, candidly. And Leonard Green, as far as I can tell, has never been involved in telling me what I can and can't do on a going forward basis. So I don't believe the departure of Leonard Green will have any impact on the hospital operations or the future of the entire CharterCARE system. But let me go back a little bit because, since 2014, Prospect has done a great deal to protect and invest in the people and facilities. And in keeping with its original commitment, it invested its initial $100 million. And despite many of the claims that have been made publicly about the investments in Rhode Island, the facts have been verified by the 36-page affiliated monitors report. It is their job to look at this. I have lots of things that go to the Health Service Council or lots of reports I see over the years. I don't always like what those reports say, and I may not always agree with them, but it's not my job to overturn them. So we actually agree with the conclusions of the AMI findings about the 2014 commitments and requirements, and we agree with them. I'd like to go through with just a few of them to understand where we stand. The first is Prospect. It says in the report, the first item is Prospect has met or exceeded the conditions required for the 2014 acquisition of the facilities, including Roger Williams, Our Lady of Fatima, Southern New England Rehab Center, and St. Joseph's Health Center. These commitments were a pledge of at least $100 million. We have exceeded those, and beyond those due dates you keep talking about, we continue to invest. This hasn't ended. We're an ongoing operation. Don't think that that was a magical date and things suddenly stopped. The second is that we've exceeded that $100 million in both the capital commitment from what was called the corporate office, as well as the local investments. So if you look details, we had two buckets. Both of those buckets, as you saw from the early numbers, when you add them together, goes well beyond the $100 million. We've also complied, number 3 in the report, with the conditions requiring to provide benefits at benefit levels comparable under the existing hospital plans when it was acquired, including vacation, sick leave, holidays, health insurance, 401k, life insurance, and continued COBRA coverage. The fourth item was Prospect has complied with the condition requiring to provide care through sponsorship and support of community-based health programs. The fifth was Prospect has complied with the conditions requiring it to adopt the existing hospital's charity care guidelines. Any of you can meet me at any of our new emergency rooms, which we're very proud of. We believe we have the best emergency rooms fit from a physical plant perspective in the state right now. We do not do what's affectionately known as a wallet biopsy. Whoever comes to our institutions, we take care of. We haven't at all said to people, we're not going to treat you based on your ability to pay. We wouldn't do that. It also has in there that Prospect has complied with the condition to maintain a ratio of full-time equivalent employees to average occupied beds that is consistent with accepted industry practices. These are things that AMI has found. This isn't Jeff Liebman talking to you. This is the outside monitor, the independent monitor who has gone through a multi-year study of what's been going on here. We've also continued the provision of necessary services and outreach to the local community. Glad to send that later to you of all the community activities we have if you'd like. We continue to protect the hospital's employees' salary and wage basis, seniority, and benefits. Again, they verified this. And we've continued to maintain the Catholic identity of Our Lady of Fatima Hospital. Do not forget, this is the only Catholic hospital in the state. Certainly, personally, I'm not qualified to talk about those things, but it's good that we agree with everything that the monitor has said. And let me talk again about what their conclusion was on page 35. We are confident in our conclusion, AMI's, that Prospect has met and exceeded the requirements of the HCA decision. Let me also say, though, something that we ought to talk about. What would not have happened had Prospect not come here? And I'll just list a few. I could go on for hours about this. But the first is there would not be the newest emergency department in the state at Roger Williams Medical Center, which also features the only dedicated behavioral health unit, a 9-bed holding area, a 20-bed observation unit. We have lots of crises beyond COVID where we treated nearly 1,300 inpatients. We also have a mental health crisis. As you can imagine, mental health is not one of those very, very profitable services, but we know it's essential to our communities, and that's why we invest in it. We've created a state-of-the-art, there would not be a state-of-the-art pharmacy and chemotherapy program that we have at Roger Williams Cancer Center, had Prospect not been involved. If Prospect wasn't involved, there would not have been major physical plant improvements. Come see the new patient rooms at both hospitals. Come see the public hallways and the public entryways. We have lots of new equipment, including most recently the purchase of spine surgery, specialized robotic surgery for Our Lady of Fatima. We've maintained the only level 4 substance abuse treatment unit in the state at Roger Williams. And we have promoted and believe in value-based contracting through the physician network that's been created and developed and promoted primarily by us. We also have been good citizens in terms of paying taxes. So if you look at North Providence and Providence itself, we have paid, in 2020 alone, CharterCARE paid over $875,000 to the town of North Providence and $2.7 million to the city of Providence. If we weren't here, that would be significantly impact the communities. So, we continue to be what I would call beyond just good citizens, but also high tax-paying entities that are here in the state. In fact, having lived in Rhode Island, I wish we had more tax-paying entities in the state. I think it would help us in many ways. With regard to the current application pending before the Department of Health and the Attorney General, there is no change in the operations or governance of CharterCARE by this transaction going through. The transaction is a change within the current ownership group of the parent company. It does not change what happens in Rhode Island at all. Rhode Island is now the only state remaining for approval. And it's quizzical to me why, but I think I'm getting a feeling after tonight's conversations. I look forward to the founding members, Sam Lee and David Topper, being more focused on the operations. In fact, being able to be more nimble and move more quickly in providing me support. I really can't comment on what happens in other parts of the country, but that is not my experience here. My experience is that things have gone fairly well, in fact, very well, given what the pressure that hospitals have been under for the last several years. When Prospect also invested in Rhode Island, it generated tens of millions of dollars in economic activity here. I mean, you really, it's hard to quantify that, but again, I'd be glad to do more research if that would help. We have absolutely conclusively met or exceeded our commitments and our obligations. There will be no change in daily operations when this goes through. There'll be no change in clinical programs. There'll be no change in our ongoing community commitments and support that we have. So I'm looking forward to this moving forward, with all due respect to the Senate members. And I'd be glad to answer any questions you might have.
Jeff, thank you very much, and thank you for presenting the testimony tonight. I have a few questions, and I'll ask one, and then we'll go around to others as well. With regards to the comments made earlier with regards to, I realize your concern is Rhode Island. That's good. We like you to be concerned about Rhode Island. That's where we are. With regards to conditions that were placed a part of the 2014 agreement. So we heard from one side that there were things that should have been reported, and that's why we're concerned about other states, because you're part of a larger organization. While you're Rhode Island, you're part of the overall organization. While you're an entity in the whole, the large. You're not unto yourself, basically. With regard to those conditions, can you speak to the conditions that manifested themselves between once the agreement was in place, the 3 years after? And were they reportable incidences within the 3 years or not?
Well, again, I didn't start here till 2018, but I will tell you, since I've been here, I have not, and I don't know exactly what goes on in other states, but everything that I have heard, or the majority of things, happened as this company was growing and evolving. This is a company that's been around for 20 years. I was with Stewart Healthcare for a number of years, and I can tell you that at different locations, things happen, but it doesn't necessarily impact the operations at other hospitals or other entities. If there was a roof leaking in California, that does not impact the person sitting in the inpatient bed, or Our Lady of Fatima, or Roger Williams tonight.
I don't disagree there, but billing of CMS, I've been on the Senate Finance Committee for 13 years, subcommittee chair for Health and Human Services, and every day I learn more and more about Medicare, Medicaid, et cetera. So billing practices in a company, it's a company, it's a company, it's a company. I'm not saying you're all the same, but it's part of the company. So I can see that might be some concerns that might exist in other areas. So I guess we will certainly go back and look at the conditions of 2014 on that application, what manifests itself outside of Rhode Island, if those conditions should have been reported, and were they reported or not reported, and shame on us in Rhode Island if we didn't do something about knowing what was there or not there, and whether AMI looked at that or not. There's certainly more to look at.
Yeah, can I just comment on AMI, because I did sit through some of those meetings.
Sure.
AMI, and I've been around a while, this is not my first rodeo, as people can tell. AMI did an incredibly extensive, thorough, comprehensive job.
Okay.
I sat in those meetings. Those were detailed conversations. They really pressed the local people on our accounting staffs locally very hard. I was there in the room when they asked detailed questions. And while there may be accounting principles, because I'm not a CPA, that you can argue back and forth, I think you could not make a comment that AMI did not do a good job, at least in pressing and asking the right questions of the finance people who work for me.
Mr. Chairman, there's something on mute. Can't hear anything. I'm not sure if your mute button's on. Thank you.
Senator, thank you very much. Appreciate it. Thank you. With regards to the application that's pending, as it relates to Lee and Topper buying out Leonard Green, basically 40% wanting to acquire the other 60%, so they have 100%. The number of 11.8, 12 million, whatever the number is, based on what I've read, and I've read a lot, I'm not sure sometimes what I read, because I read one, the next thing I read contradicts what I just read, and it's hard to compare the two. Can you comment, is that in fact the right number?
I am not familiar with how they came up with those numbers or what those numbers include. There could be assets, liabilities, a variety of things. I don't get to review the entire company's financial statements, but I will say this. I believe that Leonard Green is a successful company, as are these two gentlemen, and I would be very surprised if a negotiation was held and one party got some sort of special benefit over another. I think you'd have to look at all the things that were put together as they came up with those numbers. And I am sure, because it's a private negotiation, that a lot of that information is confidential.
Okay, I would believe that as well, just given the nature of the number and given that it's 60%, 40%, there's other things that we don't know about. So, and I understand it's private business. You're a public company. Those are confidential agreements, I guess, between the parties. So when we look at accessibility, affordability, and quality, right? From a hospital perspective, we as legislators, from an oversight perspective, from a legislative perspective, whatever, we all care about our constituents. We care about access, we care about quality, and we care about affordability. On the for-profit side, there's another factor there. The for-profit side has to care about profits. You have shareholders. You don't have profits, you don't have shareholders, right? So the assets all play into the improvement on the assets, the behavioral stuff. So thank you for doing that, what you've done with substance abuse and behavioral health. Absolutely, we need more of that in the state. But when we try and weigh affordability, accessibility, and quality, and on the flip side, on the other side of that equation, is the piece associated with profit. It causes.
Yeah, Mr. Chairman, if I could inject one thing. I spent 7 years in the Mass General Brigham system, and 8 years in the Beth Israel, now the Beth Israel Lahey, used to be Beth Israel Deaconess system. And I will tell you, having gone to those finance committees, having worked in those systems are just as aggressive or more aggressive when it comes to profits. They did not get to be Mass General Hospital, okay, by not focusing on that. They did not get to be Beth Israel Lahey. And we can have lunch sometime or talk about it offline. I can tell you about the techniques they use, but they are very focused on financial performance and very, very focused on the financial viability and the roles those CFOs play in the company in some ways may even be greater than the roles the CFOs play in other for-profit companies. And I say that having been in those systems as well as Steward Healthcare. So I've seen both sides of the equation, but I don't think anyone on this committee should think that large, successful, academically driven systems or large, successful hospitals are any less financially motivated than for-profit systems are, because it's just not true.
Okay, I don't disagree with regards to their focus on affordability, because they need to be focused on affordability and costs. It's just that on the for-profit side, there's another dimension you have to address. Other questions from the committee before I continue? So I have one or two others, Jeff, for yourself.
Sure.
With regards to the pension piece, and we're not talking about pensions here, but that was a piece of the past with regards to that piece that was satisfied with the $14 million and the commitments about making money going a little further from there. And we're going to look into that. I've taken many notes of actions we need to take moving forward from here, including a potential another hearing on the topic, I think, because we're about to exhaust everybody, and we still want to get to, we have a few folks on the phone who will call in to testify. There was a $14 million commitment in the beginning when the acquisition happened, and subsequent to that, they believed the number was much higher than that. So that was a challenge with regards to the pensioners and the pension system that existed then and what happened subsequent to that. So comment on what transpired. I know you weren't there then, but you're in front of us now. So you're CharterCARE to me. So.
Yeah. So my comment is I think it's a good news story. The pension's been resolved. It's my understanding. Things have been worked out, and it's for the good of the employees of Our Lady of Fatima, which is my primary concern. Mm-hmm. I don't hear any complaints from the employees about the resolution of how it all worked out. How it got there and along the way, I don't think I could go back and piece together all those steps. And I think there's a lot of moving parts back and forth. I will tell you that there was no decisive legal action that I know of that required Prospect to resolve the pension issue, but it was resolved.
I think I'm not saying if it's completely resolved, we may disagree on that piece. But it was a critical situation of many people that work there. So that's the other part of a for-profit entity taking over a not-for-profit entity.
Well, I would, and again, let me push back a little bit. I can point you to many not-for-profit hospitals with underfunded pension plans
I'm not saying that's not the
throughout
case.
the region and throughout the country. I can point to state governments with underfunded pension plans. Now, what the number should have been or was, I wasn't here in 2014, but believe me, that is a concern that you find. I mean, I believe in the Care New England system right now, as I understand it. Again, looking from a distance, there's a concern about whether or not there's proper
Okay, but
funding for the pension.
But there was a situation here that from when it went on not-for-profit to profit and what manifested itself after that, and that's a situation we're talking about what we have in front of us here. So other questions, and I have one follow-up on. Any other questions from the committee? So, Jeff, you heard me talk to Chris with regards to other folks I certainly like to talk to. I think this committee would like to talk to, that being Swiss Towel, Weishart, maybe Del Sesto. So you are CharterCARE to us tonight. So thank you for being here. We appreciate that. In reading through the documents that I have, and I've read through a lot of them over the last N number of months. Like I said, every time I read one, I go back and read something else because I think I read something different over there. So it's a true thing of there's three sides to every story. Yours, mine, and somewhere in the middle. And I think Max and Weishart have gone through a fair amount of that. We can certainly bring them in to testify if we subpoena them, I think from my understanding of the settlement. We'd rather not have to do that. We'd like to be able to say to CharterCARE, whatever, that you allow them to come talk to us. So I put that out there. Your thoughts about getting back to this committee, or even tonight. You could say yes, and we're good. If you need to go back and look at that. So my request is we'd like to bring them in to talk to about this, the next, because there's still, from what we've heard tonight, if you were sitting over there, wherever there is, you couldn't put this story together. The pieces would not be congruent with each other.
Yeah, well, my reaction to that is I believe both sides of that party negotiation are now relatively satisfied, and I don't know why we would go backwards. I think everyone wants to go forward now that they've reached a settlement. I have no idea the detailed conversations because I wasn't sort of the inside player on the pension discussions, but I will tell you that I believe that if we've reached that after decades of problems with that pension plan, that greatly predate Prospect taking over CharterCARE. I think what we ought to do is look out of the front end of the windshield on the car, so to speak, and move forward so we can focus on the important things, which we were talking about before. Better health care for our citizens, access, quality. I mean, there's real work to be done in Rhode Island and certain challenges. I mean, there are things going on now and where we have to really move forward and pull together. And it looks to me on the pension issue like the primary relators in that conversation are now satisfied. So I think we ought to move forward and talk about, now, obviously you have the power to do other things, which I don't have. But my advice would be if both parties are happy in that transaction, then both parties are happy. And I don't hear any complaints, again, from the employees, the citizens involved, et cetera.
So Jeff, you stole the clear phrase I use a lot, and I'm going to reuse it. I use the phrase of my windshield, my rearview mirror is this big, and my windshield is that big. I do have a rearview mirror to understand and appreciate what was behind me, to understand what might be coming up that I need to be aware of. So it's not the case of going back and opening up. That's not our place. But it's the case of being able to have conversations with them, not about the pensions. The pension stuff's over. That's over here. It's about what they've been able to evaluate and, I don't want to say uncover, because that comes across in a negative fashion, but what they've been able to assess, the facts they've been able to gather, the data they're able to bring to the table that would give us insight about this application that's pending before the Attorney General with regard to the transaction. So I have nothing about pensions. That's done. That book's closed. They signed that. But I believe in reading through the settlement, they can't speak about anything. I can't ask them I couldn't call them and ask them a question about the conditions of 2014. Presumably they have facts and data to talk about that based on the work they did in relationship to where money went as part of the conditions over the 3 years. I can't even do that. Like I said, I'm an engineer, I'm not a lawyer, but in talking to lawyers, that's what I've been advised, is that they cannot come to talk to us unless one of two things happen. One, you say, okay, they can come talk to us, or two, we have to subpoena them or we have to ask them, they have to say no, and we got to go through that whole long harangue. But pensions are not a part of it. So if I said that, I stand corrected. It's not about pensions. It's about the facts and data we want to gather to ensure going forward this next pending application and anyone beyond that might happen, we have the right things in place from an oversight perspective and legislative. So would you agree to, can you go back and let us know whether you can allow them to come to us or no?
So I can tell you right now, you shouldn't count on that.
Okay, so I'll take that as a no. Thank you. So if we do get them a letter, that we should expect the answer to be no, and then we have to go the next step from there.
Well, you're assuming they'll answer no just because we want them to answer no. They might answer no because they want to answer no.
Well, I'm just saying, well, they can't. Whether they can or can't, like I said, I'm an engineer, I'm not a lawyer. From reading the language of the settlement agreement, it says they can't speak about anything. So regardless of whether they want to or not, or don't want to or not, they're bound by what that agreement was signed. So, okay, I just wanted to make certain. I'd rather go the path of least resistance, if need be, as opposed to swimming upstream. And I don't swim well, so.
I understand.
Okay, my screen died, but other questions or senators have comments? If you do, please speak up because my computer here is negative, so. Okay, we have a few folks to, if you don't mind hanging on, Jeff, Chris, and Miriam and team. We have about, I think, 3 folks. Thank you very much for the time tonight. So, I think it's 3 altogether, yeah. No, maybe 4, 3. Hang on, folks, we're almost there. You'll hear the beep. Is this Eleanor? Is this Eleanor?
Yes, it is. Yes, it is.
Eleanor, thank you for being here. Is it Eleanor Milo?
Yes, it is.
And Eleanor, you're associated with CharterCARE Health Systems, and you have no position.
Yes, I am.
Okay. Eleanor, thank you for being with us tonight. I much appreciated. I'd ask if you can try and keep your commentary to 3 to 5 minutes would be appreciated.
Sure. So my name's Eleanor Milo. I'm the current sitting Chief Nursing Officer and Vice President of Patient Care Services at Roger Williams Medical Center, part of CharterCARE. I have been in nursing, we'll just say, for greater than 20 plus years. And I have been with Roger Williams CharterCARE for just about 2 years at this time. I have spent the majority of my nursing career in nursing leadership and senior leadership positions in the Dartmouth system, the Tenet system, the Steward system, and now the Prospect system. I can say from a nursing perspective and quality care of patient care, Prospect has provided us many things to help us be a sustainable organization. I was not here, obviously, during the time frame of the changes in 2014, but what I can say is the time that I have been at CharterCARE, there's been nothing but full support for nursing and services to ensure that we have the services provided for patient care for high quality. I would match our quality of care against any organization in Rhode Island or across the country. I think in nursing, we just came off of probably a serious pandemic in our country that none of us have ever experienced in our lifetime, and I'm sure none of us want to have to experience that again. And I can say during that pandemic time, I had nurses who cried every day, who broke down every day, who were the care providers. They were the family when families couldn't come into our hospitals and organizations. And those people came back every day to give their heart and soul to care for our Rhode Islanders, their family members, their community members, every nurse, every doctor. And I can tell you back behind all of them was Prospect holding us up and helping support everything that we were doing, from ensuring they had meals to eat to ensuring that there was never an issue with PPE. There was never a day during that entire pandemic that we did not have the adequate PPE to protect our staff and our patients, so that we were taking superior care of them and getting them through this pandemic and their illness. You know, I watched on the news and just broke my heart to see nurses not having masks or people cutting up garbage bags to help protect themselves. Those were things that were never, ever experienced in CharterCARE. We had all the masks we need, isolation gowns we needed. We were flooded with equipment to make sure we had ventilators, much-needed ventilators for patients, that we had the much-needed monitoring services for patients to ensure that we were able to provide the care that we needed. So we definitely were very supported by Prospect. And outside of the pandemic, when I have emergency capital needs or something going on with patients, they're always there to support what we need. They help govern us, show us, lead us through our quality initiatives. They help monitor and implement programs to help us achieve the highest, greatest quality that we can within Prospect and at Roger Williams. And they have been nothing but very supportive and positive to the organization. That I would, you know, knowing what I have learned in the short time that I've been there, we're very fortunate to have them to be able to support us. They give us great knowledge and networking across the country to learn and grow from each other and to support each other. So my time as the Chief Nursing Officer at Roger Williams Hospital, I would say there's high quality care going on for patients. There's definitely accountability to what we do, and we treat anybody and everybody for anything that they may need. Our doors are open for them. From the front door of our emergency department to the time that they're discharged, we take care of complex patient care issues, and very proud to say that we have a wonderful emergency department, and the new behavioral health emergency room area is absolutely wonderful to support some of our most vulnerable populations in our community. If you're talking to me, I can't hear you.
Thank you. I need to have my button up. Thank you. Eleanor, when did you join CharterCARE? Was it 2015 or 2016?
So I joined CharterCARE 2 years ago.
Thank you. Okay.
So 2019, yep.
Sorry. Thank you very much. I was trying to take some notes and I didn't write that down. Thank you very much. Any questions from the committee? Eleanor, again, thank you very much for being with us. It's appreciated.
Thank you.
I'm surprised you couldn't see what I was saying through the mask, unfortunately. Lynn? Good evening. Is this Lynn Leahy?
Yes, it is.
Lynn, thank you for being with us. Lynn's associated with the CharterCARE Health Partners in no position. Lynn, over to you. If you can try and keep your testimony to 3 to 5 minutes, it would be appreciated, but thank you for being with us.
Okay, thank you.
Over to you, Lynn.
Okay, good evening, everyone. Thank you for having me and giving me the opportunity to speak to you tonight.
Thank you for being with us. Lynn, associated with the CharterCARE Health Partners in your position. Lynn?
Yes.
Testimony to 3 to 5 minutes will be appreciated, but thank you for being with us.
Well, thank you again. Thank you for having me. My name is Lynn Leahy. I'm the Chief Nursing Officer and Vice President of Patient Care Services at our Fatima Hospital, part of the CharterCARE. I've been at Our Lady of Fatima for going on 54 years this July. Since I've been there, being part of them with Prospect overseeing us, I've seen a true collaboration of bringing practices to our bedside. Our nursing staff really cares for our patients. They are always committed to provide best quality care and being selfish, particularly during the pandemic. Our staff was exceptional and every day. They had all the supplies that they needed. And I am happy to say, being a lady at Fatima, is very collaborative work with our union members. Anything thought that we could make things better for our patients and also to care for each other during this time. Since the pandemic has come almost to an end, we're hoping, I will say that nurses are very excited about getting back on track. Started numerous care governances and nurse councils unit prior to COVID. That COVID is going away. We're back in full swing. We're working on workflows, retention plans. Never had a problem requesting new FTEs for any of our clinical staff to go along with our additional patient volume. Prospect has been very supportive in equipment, as Mr. Liebman has told you. We're very excited with our physicians onboarding, our surgical department is booming, and we're looking forward to our new robotics coming soon. But I have to say, it's been nothing but good. I've been Lady working so closely with our local senior leadership team, as well as thank you for having me again tonight.
Lynn, thank you very much. Thank you for being with us. Lynn, how many years have you been there? I didn't quite hear that.
I've been at Our Lady of Fatima since July 7th of 2017.
Thank you very much. Thank you. Any questions for Lynn by the committee? Lynn, thank you very much. We have one additional person to testify tonight. Hang on. Lynn, are you there?
I am here.
Thank you, Lynn. We have Lynn Blaze, RN. Lynn is associated with United Nurses and Allied Professionals Oppose. Lynn, over to you. If you could try and keep your comment. Sorry, Kim. Lynn, I ask if you try and keep your comments between 3 and 5 minutes, it would be appreciated. But thank you.
No problem. I know you, Senator, and the rest of the committee have had a long night, but I want to thank you for taking on this very important issue. My name is Lynn Blaze, as you said, a registered nurse of 37 years, always within the St. Joseph's Fatima healthcare system, an actual 1984 graduate of the School of Nursing there. Currently, I'm the president of the UNAP, but I am the past president of the Fatima RN local that's part of the UNAP. Just for some history, I was a strong advocate back in 2014 for the purchase of the hospital by Prospect Medical Holdings. We knew at the time that we were in dire straits, and we were looking for the knight in shining armor to come riding in to rescue us. And they came in and sold us a bill of goods that sounded wonderful. And I will say most of 2014 was the honeymoon phase. Things went well, no major changes in the hospital. From that point on, though, it was like a bait and switch. You started to see long-term managers exit the facility, people that have been committed to the organization for their entire career escorted out of the building. You started to see changes in service lines. You saw clinics closing, the sale of the nursing home. You see subcontracting out of services. You started to see a lot of changes in the equipment and the supplies that we used. The environment was definitely now one of profits over patients. Every decision that is made is about how we can make a dollar. We saw increases in our infection rate, increase in our patient falls and injuries. You now see a facility that was known for longevity of employees to an organization that now has an extremely high turnover rate. When I say I've been there for 37 years, that was usually the rule, not the exception. Today, that's the exception to the rule. When employees are now exiting the organization, they're leaving comments that they see that it is definitely profits is the priority, poor working conditions, overwhelmed, understaffed, poor management. These weren't comments that we saw years ago, so this is a whole new environment that we're dealing with. This leaves now our units working short, understaffed, working with many new young nurses who are trying to learn the ropes. We see on a regular basis equipment and supplies not being available, being told that things are on back order or there's a national shortage, which we all know shorthand is we haven't paid the invoice, so we've been shut off. I listened to the new CEO from Roger Williams prior to my call, and I do take affront when she mentions PPE. We had a major issue at the beginning of the pandemic in March with PPE. I was told personally that we had a shortage of masks. We were about 2 weeks behind every other hospital in the state, mandating that all employees wear a mask when they're at work. And I was told it was because we had a plane sitting on a tarmac in another country with our supply of masks, and we didn't have enough to get through the week if everybody was putting on a surgical mask. We had issues with gowns. We had to start washing gowns inside the facility because we did not have enough disposable gowns. We were being asked to reuse gowns between COVID patients instead of changing them per protocol between every patient. So when she says that they were there for us with PPE supplies, that's not the case. We had a unit of 21 geriatric psych patients where 19 of them converted to a positive COVID status in the very beginning of the pandemic because we didn't have enough PPE. 75% of the staff on that unit also contracted COVID-19. The supplies are never monitored for quality. We get whatever is the cheapest, and the supplies change from day to day, and that's how we know they found something that was probably 2 cents cheaper. As for the pension crisis, that is something where we were lied to when the sale went through with the pension. And we were told that they were going to fund it so that the ratio was appropriate, that it was going to be at a level where people could count on that pension. To watch a crisis unfold and to see the heart-wrenching issues that the pensioners faced is something I will never forget. You had a hospital where you had many husbands and wives that worked there for their entire career, and they're looking at a 40% cut in their pension, not knowing how they would be able to survive, how they would put food on the table, buy their medications. And we're talking about pensions that are not exorbitant pensions. They're not multi-million-dollar employees. You are talking about people that are getting probably $500 to $1,500 a month in a pension. And if you look at a 40% cut, it really has a severe impact on that family. And this is a fight that should have never happened, and it's still not over. When they keep telling us, yep, it's settled, it's over, we are not at a funded status where that everyone can count on having a pension for their lifetime. So we will continue to fight the good fight for all of the pensioners, union and non-union. And I don't know who Jeff talks to because it is still a topic of conversation and anxiety for many of the current employees inside the building that he is the CEO for. But probably goes to the point that if he walked the hallways, 90% of the people in that building wouldn't even recognize him as the CEO. So I digress, but I respectfully ask that you take a deep dive into the inner workings of Prospect before you give Sam Lee and David Topper 100% ownership. And if possible, find a way to stop them from using our hospital as a personal ATM machine. And please find a way to get them to return dividend payments and put it back into the hospital so that we can care for the citizens of Rhode Island the way that we so desperately want to. Thank you for your time.
Lynn, thank you very much, and thank you for taking the time to be with us tonight. It's appreciated. Questions from the committee for Lynn? Lynn, thank you very much. That ends our... Thank you, Lynn. We appreciate it. That ends our public testimony. I want to thank everyone for all the committee members, obviously, for the time in working through the material that we received from everyone. Much appreciated. There is certainly more work to do. I think based on what we heard tonight, based on what we received, what most of us have read through prior to now, what we will read through subsequent to tonight, certainly deserves, from my perspective, and we'll see what we need to do next on the topic, but this doesn't close the book, I think. It closes a chapter in what we need to look at, and we certainly need to move forward, and I'll say starting the next chapter and looking at what are the additional facts, what's the additional data we need to ensure, because I know based on what I heard tonight, I can't put that puzzle together like this. It's not fitting together yet. Maybe for everyone who's been involved for 7 years, you have a very clear picture. I do not, but clearly tonight's hearing allowed us to put that a little more into focus so that we can see what we do moving forward from there. So with that, I'd like to ask any member of the committee if you'd like to make a motion to adjourn tonight's hearing.
So moved.
Second.
Motion made by, was that Senator Acosta? Seconded by Senator Seveny. All in favor?
Aye.
Aye.
All opposed?
Aye.
Folks, thank you very much. The hearing is adjourned. Thank you.